When dividing assets in a divorce, the process of securing your wealth can end up consuming it. You start with a defined pool of resources, but the friction of the legal system slowly dissolves what you're trying to protect. In 2013, the Legal Aid, Sentencing, and Punishment of Offenders Act essentially removed public funding for standard divorce cases. Unless you have specific evidence of domestic abuse or an immediate risk to a child, the state will not cover your legal fees. You are responsible for funding the litigation yourself. This creates the proportionality trap. In the JVJ case, the judge noted with frustration that lawyers' fees had managed to drain an entire third of the family's total wealth. This chart shows the framework for making these funding decisions. We have legal complexity on the horizontal axis and your available financial resources on the vertical axis. In the bottom left, we find the forced DIYer. This involves a relatively straightforward financial split, but with very little liquid cash available to pay for help. In the center is the squeezed middle. You earn too much for legal aid, but too little to hand a lawyer an open-ended hourly retainer. Finally, in the top left is the asset-rich, cash-poor persona. Your finances are complex, perhaps tied up in property or business, but you have zero liquid capital to hire a team. Where you land on this chart determines your funding strategy. To protect your final settlement, legal professionals should only be deployed when the return on that investment justifies the cost. Option A is the traditional route, hiring a lawyer on a standard hourly billing structure where the meter is constantly running. Funding this usually requires draining savings, relying on family, or taking out high-interest litigation loans. The benefit is absolute coverage. You get full case management, expert negotiation, and a shield from direct conflict with your former partner. The trade-off is the risk of costs running entirely out of control. The court is so wary of this that they require a Form H cost estimate at every hearing to monitor the total spend. For those with high assets but no cash, there is option B, the legal services order. Under the Rubin v. Rubin criteria, this is a court application to force a wealthier ex-partner to pay for your ongoing legal representation. The requirements are strict. You must prove to the court that you've already been refused commercial loans and that no law firm would agree to a deferred payment plan. It creates a difficult irony. You often have to spend thousands on a lawyer just to fight for the right to have your ex pay for that lawyer. While traditional retainers and court orders offer maximum legal protection, they carry the highest risk of wealth depletion. They demand that the client constantly monitors the cost-benefit ratio. Option C is self-representation. In the eyes of the system, you are now a litigant in person. The primary benefit is eliminating hourly legal fees, preserving your capital for the final settlement. The reality is that you are now responsible for everything. You must personally navigate the family procedural rules on your own. If your ex has a lawyer, that professional cannot take unfair advantage of you, but they are also strictly forbidden from offering you any legal advice. The dangers include making procedural errors, failing to uncover hidden assets, or agreeing to an unfair deal out of sheer emotional exhaustion. Self-representation is a powerful savings mechanism, but it transfers all of the legal and procedural risk directly onto you. If we look at this comparison matrix, we find a middle path between the two extremes. Unbundling bridges the gap. It allows you to protect your assets without going it entirely alone. You act as your own litigant in person for routine work, but pay a lawyer a flat fixed fee for a highly specific task. This could be paying a solicitor only to review a final deal you've reached, or to officially draft the legally binding consent order. This creates cost predictability, while ensuring that your most complex legal documents are drafted correctly. However, you must consider the Minkin case, which set the precedent for limited retainers. The court decided that an unbundled lawyer is liable only for the exact task they were hired for. If you negotiate a terrible deal yourself, that lawyer has no obligation to step in. Unbundling provides procedural accuracy on a strict budget, but it requires you to maintain full executive control over your own negotiation strategy. This flowchart shows how to map your financial reality to a specific strategy. If you have complex assets but no cash, do not default to self-representation. Research whether you can secure a litigation loan or a legal services order. If you are in the squeezed middle, avoid open-ended billing. Gather your own financial data for your Form E and use unbundled services strictly for drafting the final order. Regardless of the path you choose, you are legally required to attend a mediation information and assessment meeting. Utilizing mediation and taking advantage of government mediation vouchers is the most effective way to stop litigation costs from skyrocketing. If you are forced to litigate in person, remember that the judge is there to enforce procedure, not to give you tactical advice. Success in family court means disentangling your lives while leaving enough capital to actually rebuild. Every legal fee should be a targeted